Okay, I have 1:30 on my clock. I believe at this time it's appropriate to call the September meeting of the Board of Zoning Appeals for Knox County to order. Do we have a representative from the clerk's office here to call roll, please?
Yes. Patricia Williams, Jamie Rowe,
Present.
James Corcoran,
Present.
Ashley Williams,
Present.
Cecil Anderson,
Here.
Terry Kerr,
Present.
David Harden,
Here.
Rebecca Longmire,
Here.
and Robert Thompson. You have 7 members present.
Um,
Bob was on earlier.
oh, okay. Are we expecting him to join?
I don't not expect him to join.
Fair enough. Okay. Welcome to the September meeting of the Board of Zoning Appeals for Knox County. Members of the board are volunteers from each commission district who do not receive compensation for their work on the board and training they attend. As a quasi judicial body, we do avoid ex parte conversations and conduct our business in accordance with the Open Meetings Act. I'm the chair of the board, James Corcoran. Do we have, we should have with us have representatives from Knox County government, including Knox County codes. Could we have everyone introduce themselves from Knox County government that's here? I can't quite see everybody.
Yes, Chairman. Knox County Codes here. We have Bart Roundtree, Kelly Vaughn, Kim Jernigan, Steve Elliott, and Leo McCamera. There's also members of NPC planning staff present.
There should have been 3 different deeds.
And Liz Albertson, and we also have Aaron Fritz from our land development department available today.
Hey, everybody, this is Daniel Sanders from the Knox County Law Director's Office. And I believe Scott Davis has his microphone unmuted, and if we can hear him talking a little bit. If Scott, if you'll mute your microphone, I think during at least thank you.
Yeah, and just going forward so that we could all participate fairly and hear each other. If you're not actively speaking, if you could keep your microphone on mute and turn it on to speak, that would be very beneficial. If you're familiar at all with Zoom, there's an option under participants to raise your hand. There's a little button, and Ms. Kerr is going to be helping me keep an eye on that as we proceed, but that way we can try to keep some semblance of order as we go forward. Let's see. Our voting procedure requires 5 positive votes for a motion to be approved, regardless of the number of board members that are present. And today, I believe we said we had 7 members.
Yes.
Were you trying to get my attention?
Yes. I don't think Jamie's button doesn't work, so I'll be watching her hand to go up.
Thank you.
Okay.
Okay. Same problem as last time, I guess. Okay.
Yes.
And do I remember right? We have 7 members.
That's correct. 7 members. Yes.
All righty. First on the agenda would be the approval of minutes from last month. Do I have a motion?
I'll make a motion to approve.
Ashley Williams seconds.
A motion by Ms. Kerr, was seconded by Mr. Williams to approve the Mr. Law Director. Do we need to have that vote by roll call, or can we do that by acclamation?
You're correct. It needs to be a roll call vote under the governor's executive order. All the votes should be by roll call, and there's an additional requirement. You make a finding before you conduct the business. So I'm fine with conducting the vote on the minutes, but then there is I can make a statement. You can adopt it as a motion like we did last time to move forward after that.
Okay. Then I guess we'll proceed to vote on the ratification of the adoption of the minutes, or approval of the minutes rather.
Okay. Ms. Rowe,
Approve.
Mr. Corcoran,
Approve.
Mr. Williams,
Approve.
Mr. Anderson,
Approve.
Ms. Kerr,
Approve.
Mr. Harden,
Approve.
Ms. Longmire.
Approve.
7 aye votes.
So, Mr. Law Director, we just need to make a finding that minutes have been approved. Is that the instruction?
That's correct. Under Governor Lee's executive order, in order to conduct meetings electronically, the governing body should make a determination that meeting electronically is necessary to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak, subject to the certain conditions. I'll just note that Governor Lee's executive order has been extended several times. There are numerous bodies that are still meeting electronically. We're tracking new cases, and we're still under a mask mandate here in the Knox County. So, based on that, I think there's a substantial basis for you to make the determination.
And do we have a motion to so find?
I'll make the motion.
I'll second.
And then, Madam Clerk, if we could proceed to a roll call vote.
Okay. Ms. Rowe?
Yes.
Ms. Rowe votes aye. Mr. Corcoran?
Aye.
Mr. Corcoran votes aye. Mr. Williams?
Aye.
Mr. Williams votes aye. Mr. Anderson?
Aye.
Mr. Anderson votes aye. Ms. Kerr?
Aye.
Ms. Kerr votes aye. Mr. Harden?
Aye.
Mr. Harden votes aye. Ms. Longmire?
Aye.
Ms. Longmire votes aye, and Ms. Williams and Mr. Thompson are absent. So 7 aye votes.
So with that, the motion carries, and the board finds that meeting via Zoom is necessary to protect the health and safety and well-being of our members and the public. Okay, the Knox County Board of Zoning Appeals is authorized to grant variances to hear other matters by the Tennessee Code and Knox County zoning ordinance. Specifically, these laws prescribe parameters required to grant a variance. The burden of proving grounds for a variance rests on the applicant. For each matter, the clerk will read the request in the record. I'll then ask if the applicant or the appellant, as it may be, is present, and if there's any opposition or other speakers who wish to present. You do not have to come forward at this time. Once we determine the number of speakers for each item, we will call on government agencies such as Knox County Codes, MPC, or engineering to make statements regarding the facts pertinent to the property in the background of the request. Board members may ask questions of the governmental agencies once they've made their statements. And then I will call upon the applicant or the appellant to come forward and state their name and address for the record and present their evidence and reasoning supporting the grant of variance. If there's no opposition, each side of the applicant would have 10 minutes. If there is opposition, each side shall have up to 15 minutes. After the applicant's presentation, board members may ask questions of the applicant or appellant. We will then call for opposition of other parties who have up to 15 minutes to speak. That 15-minute applies to all parties. So if there are multiple parties which to speak, please figure out if there's a way to do so in this format, how to divide your time up beforehand. Please be courteous and considerate of other speakers who may go after you and allotting that time. And further, there'll be discussion of the case by the board, during which commissioners may ask further questions of the parties who have already testified, and the board will make any necessary determinations deemed necessary. Our bylaws do allow an applicant at initial hearing to request a deferral of 30 or 60 days without prejudice. In the event of a deferral, any opponents to a matter may be heard on the record so that their opposition can be preserved for the record. At this point, if the representative from the Law Director's Office could address those intending to give testimony and swearing them in.
Normally, we will have people raise their right hand and answer in the affirmative. This will be an admonishment to tell the truth. So if you intend to give testimony, if there's any chance that you might give testimony, you're instructed that the testimony must be the truth, the whole truth, and nothing but the truth. So help you God.
Okay. Do we have any agenda changes or corrections for this month?
I will make a note that Mr. Thompson did join us.
Thank you. Hearing no corrections, I believe we should proceed to the first matter on the agenda. If the clerk could read the item into the record, please.
Okay, it's item 4A, which is a request of Wayne Klein with Hodges, Dowdy, and Carson for waiver to appeal the August 13th, 2020 Planning Commission approval of file number 8-SB-20-C and 8-D-20-UR concept use on review for Bluegrass Road subdivision. The property is located at 09125, 9127, 9141, and 9145 Bluegrass Road, 0 Coyle Lane, and 1540 Pine Springs Road. CLT map is 144. The parcels are 11101, 111, 115, 116, 117, 11202, part of, and map 144, group NN, parcel 003. The property is zoned PR in the 5th Commission District.
Then as this is an appeal from the Planning Commission, I would imagine it'd be appropriate to hear directly from the Planning Commission initially. If we have a representative from that body who's would like to sort of inform us on kind of where we stand.
Sure. This is Mike Reynolds with Knoxville, Knox County Planning. Just a quick overview. I mean, this was a planned residential zoned property. It's goes through concept plan application, which deals more with the road layout and general lot designs from the subdivision regulation requirements, and then also the use on review development plan approval, which is dealing with other issues dealing with like the zoning ordinance requirements. And what was it, 50, I don't see, the plan had 58 lots, I believe, single family lots, so 56, sorry, 56 detached residential lots. There's only one condition of the use on review approval, which was meeting the Knox County zoning ordinance, and the concept plan had several conditions attached to it as well, but that's underneath the subdivision regulations is a separate issue. But I'll be happy to answer any questions as we go through this process, and I'll just leave that for the time being. Thank you.
Okay, and my understanding is the appellant is represented by Mr. Klein with Hodges, Dowdy, and Carson. Mr. Klein, I think I see you here. I think you've got the floor.
Well, thank you. Good afternoon, commissioners. I hope you can hear me and see me. I had a little problem with my computer earlier on. My name is Wayne Klein from the firm of Hodges, Dowdy, and Carson, 617 Main Street, Knoxville, Tennessee. And I represent land and homeowners in the Pine Springs subdivisions and neighboring Williford subdivision, which are adjacent to, Pine Springs is adjacent to the Bluegrass Road subdivision application, and the Williford subdivision is downstream from the Bluegrass Road subdivision, which is why we're here before you on appeal. My clients are appealing the use on review development plan as passed by the Planning Commission on August 13th, 2020, because it is a faulty and fatal approval. It approves a plan that violates the Knox County Stormwater Ordinance. And in other words, the MPC approval of this use on review development plan does not meet the requirements of the Knox County Ordinance. And regrettably, the planners overseeing this file and the commissioners at the Planning Commission hearing on this concept use on review failed to recognize that the stream that starts on my client's property in the Pine Springs subdivision and then runs through some of the houses' backyards and into the proposed Bluegrass Road subdivision is a blue line stream under the definition of blue line stream in the Knox County Ordinance. If the stream is blocked up by the development, as has now been approved by the Planning Commission, it will cause flooding of the stream and a hazardous increase in flooding on Bluegrass Road which is upstream from the Williford subdivision. And flooding can cause those houses to be completely flooded if it's overdone. Now, what is your jurisdiction? What is your authority on this appeal? Because I heard people asking about it earlier. Article 6.50.07 of the Knox County Code of Ordinance discusses the right of appeal by my clients to this body. It states, and I'm quoting it, any person, firm, or corporation aggrieved by any decision of the Metropolitan Planning Commission relative to uses permitted on review may petition the Board of Zoning Appeals to consider the same. Now, subsection B of that article, 6.50.07, states your power under these circumstances. The board, and I'm quoting, the Board of Zoning Appeals shall consider de novo in public hearing and may affirm, modify, impose restrictions as provided by Article 6, or overrule the action of the Planning Commission. My clients are asking that this body act appropriately with that authority to deny this concept use on review to prevent the stream from backing up and flooding homes in Pine Springs subdivision and Williford subdivision, as well as some of the homes in the proposed Bluegrass Road subdivision, and also to keep the existing flooding that happens on Bluegrass Road from destroying homes in Williford subdivision from increased water runoff down over Bluegrass Road. Now, Knox County ordinance and its stormwater ordinance defines a blue water or a blue line stream. And I'm quoting, a blue line stream is any stream that is shown on a 7.5 minute USGS quadrangle map, unless determined otherwise by the Tennessee Department of Environmental Conservation, TDEC. I attached to my letter, and each of you should have a copy of my letter. The last page of my letter is dated September 18th, folks, of this year. It's a color copy of a 7.5 minute USGS map, which I would move to be admitted into the record, showing the blue line stream, and it shows the source of the blue line stream in the Pine Springs neighborhood and its flow from its origin through properties on Pine Springs Road and onto property. There it is. That is part of the proposed Bluegrass Road subdivision. The blue line stream, you can see it is actually blue on the color map. This blue line stream is protected by the Army Corps of Engineers, TDEC, and Knox County Ordinance because there are jurisdictional waters. Impacts to blue line streams and other perennial, intermittent, and ephemeral streams, once jurisdictional determination takes place by TDEC, require permitting by TDEC for the site. Once TDEC makes a determination of whether this blue line stream is a jurisdictional water and what permits must be issued, then and only then can the applicant's concept plan use on review be modified to meet the requirements of TDEC and the Army Corps and Knox County's ordinance. The Knox County Stormwater Ordinance, section 26-223, titled, quote, design criteria, end quote, requires buffers around a blue line stream, and water quality buffers must have a minimum width of 50 feet from the center of the stream along each side of the blue line stream, with an inner zone of 25 feet from the center of the stream, which must remain undisturbed. It appears, and I'm not an engineer, and it appears to my clients from the applicant's concept plan that the Bluegrass Road subdivision, as it is now drawn, will not only violate the buffer zone, but also build right on top of the blue line stream. So your applicant must comply with regulations controlling the blue line stream before the development plan, the use on review, the concept plan can be effectively considered. And this board must act today to overrule the Planning Commission's approval of this use on review for the Bluegrass Road subdivision. Why? You might ask, why must we overrule it? My clients had to appeal the Metropolitan Planning Commission's ruling. If you approve or just modify it, it becomes a final rule, and that excludes my clients from the process of protecting the Blue Line stream. And so you may have to engage your attorney to discuss this, but allowing the applicant to proceed with an approved use on review and consent plan without a jurisdictional waters determination will violate my client's rights to participate in the process and ensure proper compliance before Bluegrass Road subdivision's use on review and concept plan is approved. A conditional ruling today is not appropriate under these circumstances, commissioners, because my clients need to keep their property rights intact, and the only way to do that is not to have the use on review approved and become final until after the jurisdictional waters have been determined by TDEC. And so I'm happy to answer any questions, and I know this is a lot to put before the Board of Zoning Appeals, but this is our only remedy, and now we're talking about remedies. Thank you very much for your consideration.
You're muted, James.
Yeah, just figured it out. Okay. Do we have anyone, any additional speakers who are on, I guess, this side of the issue?
No, I'm the only speaker, Commissioner. I'm the only one. I'm speaking on behalf of everyone. We wanted to make sure that was so that we could have enough time to answer questions and do what's needed. I will say that there's a septic line that runs down parallel to the Blue Line stream that may be, and this is up to Mr. Reynolds and his group, that may be impaired by an affirmation of the Metropolitan Planning Commission's approval of this. But more importantly, the Blue Line stream issue is our fundamental appeal today.
Okay. And who do we have on behalf of I guess, the property owners or the developers? Is there?
Yeah, Scott Davis here. Scott Davis, PO Box 11315, Knoxville 37939. As I understand your application for concept plan and use on review does not require a streamlined determination as part of the application process. We are required before we can get a permit from the state of Tennessee and TDEC to do a streamlined determination, which is part of the engineering and part of the approval processes before we can get a grading permit. It has never been and should not be, and to my knowledge, it's never been part of the concept plan and or use on review.
And Mr. Davis, do you have anything further? I do think since we're proceeding as this being a de novo appeal, it might behoove folks to flesh out the record as much as they can in terms of demonstrating why the proposed use is going to be an appropriate one and not have an impact on the surrounding area.
Yes, sir. We, as part of our requirements for approval, we have to do a streamlined determination. Just because it shows up on a map does not mean that it is a Blue Line stream. There's hundreds of cases in Knox County whereby it shows up on the map until a determination is made. Then there's no, it's either determined to be a Blue Line protected stream, and if it is, then Mr. Klein is correct. We are required to maintain our buffers, and that's a requirement for Knox County. It's also a requirement by TDEC and the Corps of Engineers. So we cannot, if it is determined to be a Blue Line stream, we cannot, there are those buffer requirements. if it's determined to be an intermittent stream, which we think it most likely is, then, and/or wet weather conveyance, then those buffers do not apply. And Mr. Sanders, I guess I would ask you, sir, is a streamline determination part of and/or required when you apply for a concept plan and/or use on review?
Okay, so I've got my hand up. I'll put my hand down. So I agree with Mr. Davis that, and I'm gonna have an interlude with Mr. Klein here in a minute. So I think we may be talking past one another a little bit on legal issues. I agree with Mr. Davis that a property owner isn't required to do a stream determination every time that there is a stream identified on property that they propose to develop. A property owner may just accept that an identified stream is a stream and maintain the buffers. But the planning commission, those sort of requirements would be included in the development plan and the concept plan, and they would be identified as part of the plan, and they would be approved by planning commission. In this case, I think there's some dispute about whether the stream identified on the map, the existing map, is indeed accurate. And so that was, and Mr. Reynolds may want to chime in here, but the way I assume this has happened is the planning commission identified that and said, indeed, if this is a stream, then the buffers need to be maintained, which would then comply with the ordinance. But if it's not a stream, as Mr. Davis seems to dispute, then those buffers would not apply. Now, Mr. Klein is arguing that that needs to be done before the use on review is approved, but the condition for the stream determination is contained in the concept plan approval. That's not been appealed to this body, but even if it were contained in the development plan approval, which I think you don't get to a permit one way or another without both things, meeting all the conditions in both things. But there's another process that I think is available to someone to appeal the stream determination, and that is under section 6.60.03, and it would come to this body, but I don't know that it's ripe to be heard at this time. And I'll quote from that section, 6.60.03 subsection A. The Board of Zoning Appeals shall have the power to hear and decide appeals where it is alleged that there is an error in any order, requirement, decision, or determination made by an administrative official. And the way that I see this stream determination being made under the concept plan approval is that the stream determination will be submitted to Knox County Engineering and Public Works. And then the Engineering and Public Works will review the stream determination, and it will make its own determination about the submitted determination. And it's happened before, and I've been involved in these before, where a property owner has submitted a no stream determination, and Engineering and Public Works has disagreed with that and ordered its own determination that showed a stream. I'm not saying that will happen in this case. They may look at the stream determination and agree with it. Mr. Davis may not be able to find an engineer to give him a determination that he deems satisfactory. But regardless, I think that if a stream exists on this property, there's going to be an additional process to make that determination, and then that process itself is appealable to this body. But I don't know that it's ripe. Does that make sense, Mr. Klein?
Regrettably, Mr. Sanders, it does not, for a couple of reasons. The Article 6.50.07 of the Knox County Code of Ordinances states who can appeal to this body and why they can appeal. And it's relative to uses permitted on review and any person aggrieved. The staff recommendation and the MPC ruling provided that a stream determination be made as to whether it's a blue line stream, and that was condition number 7. I think Mr. Reynolds was part of that process. And the problem associated with that is if this body approves and affirms the Planning Commission's decision and 30 days goes by, then my clients are without a remedy and they're out of court. And that requires me on their part to file a lawsuit, something that we do not want to do. We just want to get this right so that the blue line stream is protected. And so it is ripe under the ordinance for this body to hear it, and it is appropriate to ask for a determination before the concept plan or the development plan, however you want to say it, because they're both in essence the same thing in this case, before it is approved. If it is approved as is, and it has to move forward, then my clients cannot participate in the blue line stream determination.
James, you have a hands up with Mr. Williams and then codes.
Mr. Williams?
Sorry, I had to find the unmute. Two quick questions. Has either an ecologist or geoservices company been contacted to determine if this is in fact a blue line?
This is Scott Davis here. We do that as part of our development plan that we submit to Knox County and to the state of Tennessee. We do not do that as a matter of course until and unless we know we have a conceptual plan approved. There's a big difference between a conceptual plan and engineered plans. The conceptual plan and use on review is just conceptually to see whether or not this type of development is consistent with the area and meets all of Knox County's codes and regulations. Then we go forward with the development plan in which we engage the engineers and we spend a considerable amount of money on our determinations, whether it's a streamlined blue line stream or what other conveyance or intermittent stream. All of the issues that we deal with that are regulated by the EPA, TDEC, Knox County Engineering, we have to go through all of those hoops and get approvals from all of those sources before we can move forward. We do not, and I don't know if anybody has ever done, to my knowledge, a streamlined determination as part of your concept plan and use on review submittal.
I appreciate that.
It is not a requirement. Yes, sir.
Okay, Mr. Davis, second or the follow-up question on that. Do we have a diagram showing where the stream would flow through on the properties?
Yes, sir. If you go to the KGIS website and put in 9145 Bluegrass Road and go to the topography map, you'll see where the blue line stream supposedly originates from. And it actually originates from the detention pond that was built as part of the Pine Springs development. If it was a blue line stream, that detention pond would not be able to be there. That detention pond is the origination of what Mr. Klein is referring to as a blue line stream. It is not. That's what it originated. Go to the topo map. No, the topo. Right there, yep. All right, and then zoom in, please. And go up some, keep going. That's correct, keep going that way, keep going that way, keep going that way, keep going that way. Right there, that hatcher line you see with the straight line in the hatchers. And if you zoom in a little bit more, you'll see that that is the detention pond that was constructed as part of the Pine Springs development. That's the origin of what Mr. Klein is referring to as a blue line stream. I'm not an engineer and I'm not a geologist. I'm not anything that's associated with anything with those degrees. But if that was a blue line stream, that detention pond would never been approved. It is not a blue line stream. But that determination will be made as part of our submittals to the state and to Knox County Engineering.
I appreciate that information. On a secondary or follow-up, could the project be modified for the appropriate buffers if in fact it is determined to be?
Well, it will have to be. We could not move forward with the concept plan as submitted if that is determined to be a blue line stream. Therefore, we would have to come back to MPC. We would have to go through another use on review and concept plan approval process. If it in fact is determined to be a blue line stream, we would not be able to develop the subdivision as approved by Knox County Engineering, by Knox County MPC, or whatever you call it now. What do you call it? Planning, Knox County Planning. I still call it MPC. I apologize. But yes, you're 100% correct. Yes, sir. We would have to resubmit with a revised concept plan if it is in fact determined to be a blue line stream.
I appreciate that. I'm going to mute my microphone, my hands down.
May I respond?
Was it codes?
Correct.
Yes, Scott touched on most of what I was going to talk about, but the stream determinations are now done by a third party. Once the stream determination is done, they submit all of that to TDEC, who in turn reviews and either agrees or disagrees with that determination. And that would be where Knox County Engineering would have no part in the stream determination, other than if TDEC determines it to be a stream, we would then apply our buffers to it, as Mr. Davis said.
And whether it's a stream or not, that water will have to be conveyed to the site. If it isn't a stream, it can't be piped or anything like that, but it won't be dammed up and it will flow one way or the other.
I think Ms. Longmire was next.
Longmire?
I just want to say that in my experience, TDEC and engineers tend to err on the side of caution. So if TDEC decides that it's a blue line stream, Mr. Davis will definitely have to buffer. But with the conditions that the Planning Commission has applied, the fact, well, even without that condition, Mr. Davis is very aware that he would have to take into consideration whether or not it was a blue line stream. I really don't see the need for the appeal. I think that upholding the Planning Commission's decision is probably the right thing to do, because that stream will be considered, and TDEC is a hard mistress. I can tell you that.
Mr. Thompson was next.
Hello. I'm going to turn off my video to save bandwidth, but I see that Jamie Rowe is raising her hand but does not have her hand up. I want to make sure that she understands how to have the thing show that she's raised her hand. Hi, Jamie. Can you hear me?
I can.
I didn't see your.
I can't use the hand thing.
She's had some issues with her button.
Yeah.
You need to go down to the participants button at the bottom of the screen and then it shows you a list, and then it shows you can raise your hands.
It doesn't work on mine at this meeting or the last meeting.
Okay.
I'm sorry to hear that. Anyway, I want to defer to Jamie, but I will have questions in here in a minute when she's done. Thank you. Please proceed, Jamie.
Would it be okay if I defer to Mr. Klein, because he had his hand up and evidently wanted to say something first too, and then I will proceed if that's okay.
That's quite all right. Mr. Klein, did you have something you needed to?
Thank you very much. I wanted to refer you all before I responded to Commissioner Longmire that the blue line stream definition from the stormwater ordinance says any stream that is shown on a 7.5 minute USGS quadrangle map, which is what I've shown you. Secondly, Mr. Davis responded that there's a detention pond up there. I've walked the entire area. There is no detention pond. That's the source of Pine Springs. That's where it starts. There is no proof in this record that that it is not a blue line stream, and I have complied with the definition in the stormwater ordinance of what a blue line stream is. But most importantly, Commissioner Longmire says there's no need for this application, and I want to go back to the concept of a remedy. If you approve the Planning Commission's approval of the use on review development plan, concept plan, then once this decision is final, my clients have no right to do anything, and it forces them by remedy to go to a court of law to determine whether there's a blue line stream or not. And that is a component of today's appeal that you need to consider, in my opinion, humbly.
Thank you, Mr. Klein.
Can I respond? May I respond to Mr. Klein? I'm sorry, Mrs. Rowe. Go ahead. I didn't mean to interrupt you. Go ahead. Yes, ma'am.
That's okay. Go ahead.
Yeah, either way, if this appeal is upheld, we have no other recourse other than going to court. So it goes both ways. Mr. Klein says the only recourse they have is to go to court. And on our side, if this appeal is upheld, we have no recourse other than going to court. So I don't understand the rationale there, but bottom line is we have to go through that process to have that determination made. And once that determination is made, it is sent to TDEC. TDEC either says yes or says no, and we cannot proceed, period, until a streamlined determination is made. And that will be done as part of our submittal process to Knox County Engineering and to TDEC. And I'm sorry, Mrs. Rowe.
Okay, I watched the MPC meeting, and I certainly agree with one of the speakers who said that water always wins. I've been a victim of that, and I certainly understand that point. More importantly, to me, it's imperative to have a determination of this up front regarding environmental issues. The stream, as Mr. Klein said, is on the USGS map. This use on review certainly would have an adverse impact on the neighborhood, and it's not in harmony with the general purpose and intent of the zoning ordinance to proceed with this use on review. Actually, I have been emailing with USGS, and I spoke with TDEC this morning on the phone. And the field agent that I spoke with was able to look up a different version of what we are able to see on KGIS. It's called an ARAP viewer. She told me that it shows an unnamed tributary for that goes all the way to Fort Loudon Lake. She said it would be best to have this determination made up front.
Let's see that Mr. Sanders has his hand up. Mr. Sanders.
I am not suggesting that I'm going to make a suggestion, but I'm not suggesting that that is determinative as far as this board's ultimate decision. But Mr. Davis, you seem to understand that you're going to have to do a stream determination one way or another, and that the stream determination is, if the stream determination determines there's no stream, then you can move forward. If it determines that there is a stream, then you're going to have to go back to the drawing board essentially. One of the things that this board can do is to approve the development plan with modifications. Maybe the board can consider approving the development plan while adopting condition number 7, or by modifying it and adopting condition number 7 in the concept plan approval. I don't know that it makes much difference, but the next step for you, I think, is to get a stream determination, and you're going to do that one way or another, whether it's a condition of the concept plan or a condition of the use on review approval, the development plan. So, would you? I mean, it seemed like you're doing that one way or another. Can we adopt that as a condition, a friendly condition to the development plan approval? I think the board could do that.
Is that a question to me?
Well, I'm sort of thinking out loud here, a way that we can satisfy everybody and suggest a way to move forward.
Mr. Klein,
determinations aren't a condition of approving a development plan, and I don't think that's ever been the case. But you're not going to be able to record a plat until you have a stream determination and Metropolitan Planning Commission approves the plat. So
there are multiple layers of protection for Mr. Klein and his clients. And those multiple layers of protection are all laid out in what we do on any subdivision we do. So his clients are protected. If in fact it is determined to be a blue line stream, we come back to MPC and resubmit. If it's not determined to be a blue line stream, we are able to move forward with development. And that decision is made by a whole lot smarter people than myself. That is made by geotechnical people, and also it is sent to TDEC, and then the TDEC representatives come in and they make a determination on whether or not it's a blue line stream. Mr. Klein's clients are protected. If in fact it is a blue line stream, we come back to the drawing board and we start over again. So I don't understand why Mr. Klein is concerned. I do understand why he's concerned. I don't mean any disrespect to him and or his client. Wayne's a friend of mine. I don't have any problems with him personally, but they are protected. They are protected going forward by all the layers of approvals that are in place. The concept plan use on review is the beginning of about a 30-step process. It's the beginning of the process, not the end of the process.
Do you see the hands? I think you
I
had.
was making sure Mr. Davis was.
Okay.
Are you done?
Sorry, Davis.
Okay, Ms. Kerr, I see your hand is up.
Yes, I think Mr. Thompson and Codes were before I was, though.
Okay, Mr. Thompson.
Thank you. I'm going to undo my video just to say bandwidth, okay? So can you hear me still?
Yes.
We've had some references to the difference between concept plan and development plan, and the idea that our job is only to look at the development plan, but they are essentially the same. And I want to refer everybody to a MPC web page on use on review. I don't know if anybody can pull that up for the screen, but it's the knoxmpc.org/commission/use on review. And it says materials which must be submitted for for development plan use on review. And it's a long list. It says 10 copies, which is essentially what the rules say for concept plan. And I think the Planning Commission has admitted that the development plan is the concept plan, at least in this case. And if you look at that web page, it says the materials which must be submitted for the use on review include preliminary drainage plan. Okay, must be submitted. And then if you look, and that is based on the subdivision rules, which again, I know we're saying, well, technically the subdivision rules are not for us to look at, but the subdivision rules do say that a concept plan application must include a preliminary stormwater plan. And that the concept plan approval that the engineering and public works must submit a letter as part of the concept plan approval process, must submit a written determination that the preliminary stormwater plan seems reasonable, seems acceptable, appropriate. So it's not a final determination, but it's a stage one saying this will probably work. And I get the clear feeling that none of that happened in this case. So I think the concept plan was clearly premature. I don't know why it was rushed through, but it was. And like Ms. Rose said, I have looked at the meeting video for the August meeting, and what I saw was that the neighbors raised very valid concerns, which they've now backed up with, very convincing photos. Flooding is an issue. They said it over and over. But the only thing Public Works was able to respond to in that case was they had no preliminary plan to look to, apparently. They just said, well, based on our knowledge, we don't know about any flooding. So to me, that undermined the whole process, the whole approval process. It basically eliminated the possibility of meaningful public inputs, which is a big deal. The public already has enough hoops to jump through. It eliminated the, if the concept plan / development plan, if that case file had included a preliminary stormwater plan, the neighbors would be able to review that and make an informed reaction to it. But as it is, they just said what they could without knowing, without there having been any preliminary studies. Engineering and Public Works was not able to give a meaningful response to it. And the Planning Commission voted on it without even saying a word about it. So to me, that whole process was flawed. I'm definitely voting against this. I am definitely voting to uphold the appeal and to, so that's all I got right now, I think.
Ms. Kerr, I believe you were next.
Yes, I just had a question for Mr. Klein. So is the concern with the neighbors the spring only, or is it the fact that a subdivision is being proposed to be built? So for an example, if all of the, if everything is proven that, let's just say there's not an issue with the stream and they approved to go ahead and build the subdivision, is that, then they're okay with that? If they are, oh, everything's great, it should not flood, all the tests have been done, everything's been looked at, and we're good, are they okay with that? Or is it the fact that it's just that there's another subdivision that's being proposed to be built? What would the reaction be to that? Do you understand what I'm asking?
I do understand, and I've addressed that with my clients. They understand that there's going to be a subdivision named Bluegrass Road subdivision, and they understand that progress must take place. The major concerns having to do with the Blue Line stream have to do with whether it is or not, and they think it is based upon the quadrangle map, and what happens down at Bluegrass Road, which you've seen in your packet, pictures of flooding. And if the Blue Line stream is not appropriately dealt with, more flooding will occur, and the folks right across Bluegrass Road, which are actually downhill will experience flooding in their houses. And so this is a progressive type of concern that starts at the source of the Blue Line Stream and ends with the flooding that occurred 2 years ago and last year in our 500-year flood, where you couldn't pass Bluegrass Road next to Pine Springs Road intersection because it was flooded for 2 days. At the Planning Commission meeting, it was brought up but not addressed, and I believe our head of engineering for the county said something to the effect of, we think that the pipe that allows the water to travel underneath Bluegrass Road is sufficient. It's not, and it hasn't been for some time. And that's part of the problem that's associated with all the letters and the emails you got. And I didn't want to turn this into something that couldn't be taken care of, because the folks in Pine Springs subdivision understand they're going to have neighbors. It's fine that they're going to have neighbors. But if that Blue Line Stream is built on or prevented from flowing properly and not dealt with in terms of stormwater conditions, then they see not only flooding for their subdivision, but also for the Williford subdivision. And they see it for some of these houses in this concept plan, which as I understand Mr. Davis's testimony today, is not to be taken seriously because he's going to do something else. But that's all we've got. And that's what we have to deal with at this time. And that's the reason I looked at the ordinance and I said, hey, the definition of Blue Line Stream is right in the stormwater ordinance. And I went to the quadrangle 7.5 map and I found it is a Blue Line Stream. And I'm not an engineer either, with all due respect, but it meets the definition and therefore must be considered, and wasn't. I hope that answers your question.
It did, yes. And I was just kind of looking at that to make sure that it was not just not wanting the subdivision. And I don't understand why the studies, from what Mr. Thompson said just a few minutes ago, while they weren't presented in the beginning, I do understand the concept is just that. From my understanding, it's the concept. So if there is a Blue Line Stream, then Mr. Davis, you have to kind of start over with your subdivision plan. Is that not correct?
Yes, ma'am, that is correct. Let me offer this to see if this is, and going back to what Mr. Sanders said, and I don't know if this, Mr. Sanders, what if we ask for a 30-day postponement? We're going to be doing the Blue Line Stream determination anyways. We'll get the Blue Line Stream determination done in the next 30 days and have that determination made between now and the next meeting. Is that possible?
I wouldn't have any objection to that, but I'll go back to where I was at the beginning. I don't know that this issue is ripe, but you know, if you're willing to bring a stream determination in here in 30 days, I don't see what the harm in that will be.
Yes, sir. And we can do that. And if we don't have it done in 30 days, we can do another 38 days postponement. We're going to have to do it anyways, and that may alleviate anybody's concerns going forward once that determination is made.
Ms. Rowe has her hand raised.
I'm seeing that, but Mr. Klein, this is your appeal. Will you have any opposition to kicking this down the road 30 days to see what this Blue Line Stream determination looks like?
There, I unmuted. I don't have a problem with the postponement. My experience with Blue Line Stream determination and jurisdictional water determinations is that TDEC takes control at some point, and it could be much longer than 30 days. I mean, much longer before they get a determination made. That's my experience, and I had one done on Westland Drive, so I was part and parcel of that one.
Mr. Davis, would it perhaps make more sense if we were to talk about a 60-day?
No, sir, because if we don't have it done in 30 days, we would ask for another 30-day postponement. But we do these routinely. We do this on almost every subdivision we develop.
You feel pretty confident you'll have one in 30 days?
We have done it in less than 30 days, but with COVID, it seems things have taken a little bit longer than normal. But if in fact we cannot get it done in that 30-day window, I would respectfully come back to you all and say, hey, the state couldn't get this back to us in time. And it doesn't take Mr. Klein out of his position of his appeal process. So I don't see any harm done by postponing it for 30 days, getting the determination made to make everybody comfortable.
I guess I have a quick question for our law director. In this, I'm more used to doing this in the context of a variance. Whose case is it to ask for the 30 or 60 day postponement, Mr. Sanders?
It seems like both parties are in agreement here. It could be accomplished without objection if the chairman is willing to do that. But Mr. Thompson has his hand up. There's some others with their hands up.
Yeah, Ms. Rowe again.
Ms. Rowe, please.
Yes, the only thing that I'm concerned about, I would like for TDEC to make this determination. And they told me this morning, I spoke with Valerie McFall, and she said since it does show up on their ARAP viewer, it would be a better idea to have this done up front. Just telling you what she said. She's the field agent.
Thank you. Mr. Thompson?
Thank you. To me, again, I'm going to try to be brief for what I was raving about earlier, which is that the stream determination, to me, is not the only issue here. The issue is that this whole approval process went forward without the Planning Commission even following its own rules. Its own rules call for the preliminary stormwater plan and for a written determination from Engineering and Public Works that the preliminary plan looks like it might work. That was not done here. It led to a premature consideration. It led to wasting everybody's time, including all of our time here. It led to the neighbors having to hire attorneys. The process was flawed. The determination was flawed. And to me, it doesn't matter whether it's a blue line stream or not. The approval process was flawed. It was premature. It did not allow for adequate review. To me, again, this needs to be overturned. I don't think if we find out the blue line stream is or is not, it does not change the fact that the approval process was flawed and the consideration was flawed. The concept plan, development plan were not complete. We're not as far along as they should have been. Thank you.
I do see that there's some other hands up. But is there anyone else from the board that desires to speak before we address the issue of possibly continuing this for 30 days?
I just wanted to ask, and I think possibly planning may have had their hand up at one point. I just wanted to see if planning could respond to Mr. Thompson's, did that need to be done conceptually from what he was reading, what that process was, or is that something that indeed was okay to be done at a later date based on the information he's reading, and how that kind of falls through if indeed it's just a concept plan that could have a lot of changes to it. So I just wanted to, if you wouldn't mind just to touch on that.
Sure. Again, this is Mike Reynolds with Knoxville County Planning. So the preliminary drainage plan in a concept like this is usually pretty basic. It shows generally where a detention ponds are going to be located, and where so that like any type of drainage easements might be needed, or the infrastructure like in a street, where the piping will go, and how the water will get to the pond, make sure that everything seems feasible. As part of this review process, the concept plan review, stormwater engineering will make comment during the review process if they see issues, and get back to the engineer on the project, and they'll make modifications as needed. So there's not necessarily a letter that we get that states that this will be the stormwater part of the preliminary plan is acceptable or appears to function properly. It's more about the review process and making adjustments to the plans before it even gets to the Planning Commission to make sure that it is feasible. And then regarding the stream determination, Most of the time, they don't happen before the planning commission approval with concept plan. It does happen on occasion. I guess it's just whatever the applicant at that time, whatever their risk profile is, whatever they feel like they want to have done before they submit a concept plan, that they can do that. I would say in most cases they're not done before the concept plan review and approval. It's just a condition, usually just a condition of the approval that happens after the fact. And it doesn't happen too often where we see a concept come back because there was a determination made that the developer wasn't expecting, but it does happen on occasion where the blue line ends up being a true stream and they have to make adjustments to their development plan. They'll come back to you with a new concept plan.
Thank you.
We have, I see a couple hands up. Are those sort of holdovers or is their hand supposed to still be up?
Can Code speak a little bit to some of the concerns and questions been raised?
That's fine by me. Go ahead.
Just back to Mr. Klein on the blue line stream, it does say if they show up on the quad map, they are a stream, but it also says unless otherwise determined by TDEC. Quite often we see those show up on the quad map and they're determined not to be a stream by TDEC. And it also goes the other way where they won't be on the quad map and they'll be determined to be a stream by TDEC. So really the quad map would just be a guideline on we need to do a determination. It isn't set in stone that because it's on that quad map, it is a blue line stream. And to Mike's point, the preliminary drainage, we usually ask for those just so we can see the layout of the drainage, where the detention basin is going to be. So we could identify any potential downstream problems, where our water is going to discharge from the site to identify any problems we may see on the front end. It's very rare that we would get any type of drainage calcs or anything. And I think at the day of the meeting when Mr. Snowden referenced that, that's what he was saying is we didn't have any calculations to look at the discharge rates from the side or anything. We are committed. Mr. Snowden did commit that day that if the roadway floods down there and the pipe is undersized, Knox County Engineering will upgrade that pipe, the infrastructure to ensure that road doesn't flood. But when the road did flood, that was in I think 125-year storm event, and that pipe under the roadway is only designed for a 25-year. So, in those type of events, that road's going to flood no matter what.
And I'd like to point out that Mr. Davis has retained one of the best engineering firms in the county. Technically, you don't even have to be an engineer to do a concept plan. A surveyor is allowed to do a concept plan. So I feel pretty good about where we are with it. Thank you.
Thank you.
Based on the statements that have been, Mr. Klein, see, raise your hand.
Yeah, I think I ought to say something. If the commission is thinking, if the board, the board is considering a continuance, my clients are paying attorney's fees. I would request you consider 60 instead of 30 days. Thank you.
Mr. Davis, did you have a response? I saw you unmute yourself.
I'm not an attorney, but my father was. In most cases, it's less expensive for a shorter period of time. So if his clients are paid for him to be here, in most cases, in 30 days, if we can't get it done in 30 days, then we'll ask for 30 more days. But I don't think that a 60-day request is warranted.
Thank you. I'm going to make a motion. And one thing I would say before making the motion, I note that in looking at the approval or denial, the rules in our ordinances regarding approval or denial, one of the things that this board and the MPC is also supposed to consider is whether or not the development plan or use permit on review could be shown to have an adverse impact on the character of the neighborhood in which the site is located. And I think there's been some assertions about what could happen with flooding or not flooding. And certainly personally, I would always be happy to entertain any sort of expert testimony from someone who can say that, what this will or will not do, as far as impacting the neighborhood around it, and I'm sort of saying that to the benefit of either side on this, you know, blue line stream or not, if folks are concerned about flooding, I think I will, and I believe a lot of the members of this board would be happy to consider any sort of expert testimony about what type of impact this will or won't have. Based on the, you know, obviously we're living in sort of strange times and things are taking a little bit longer than they usually do because of, you know, COVID-19. I would make a motion to continue this 60 days so that we don't have to, you know, kick the can down the road more than once. Well, I guess that's my motion, is to continue the matter for 60 days.
I'll second.
Okay. We have a motion properly seconded. Do we have any discussion?
Am I allowed to speak?
Go ahead, Mr. Davis.
Please help me understand why we are looking at 60 days as opposed to 30.
Well, personally, and I can't speak for the rest of the board, you know, you indicated you had been able to do it within 30 days, but you also acknowledged that, you know, some of the things were going on a little bit slower than usual. Some of the other members of this board indicated that in their experience, these things can take even a good bit more period of time. And I do have to feel like we have to be cognizant and respectful of the time of everyone involved. And I would hate for, you know, for the number of people who are involved on the other side of this to have to pay council to come down here more than, well, what could end up being 3 times if we were to have to kick it down the road again.
No, sir. All I would do
That's
is
my
simply-
logic.
I would submit to you all a request to postpone, and if there wasn't anything else on the agenda, then it would be it could be postponed again, and there wouldn't be any need for Mr. Klein to have to be back. I offered that as a way to try to help resolve the issue and to satisfy everybody. I've probably done more streamlined determinations in Knox County in the past 20 years than anybody here, other than Knox County themselves. And if I can get it done in 30 days, why would we be required to extend it for another 30 days? What that ends up doing, it costs us a considerable amount of money. We own the property. We're paying interest. We're getting into the rainy season. And I don't see any benefit to anyone going from 30 days to 60 days. The burden is on me. If I cannot get it done in 30 days, then we would come back and respectfully ask for another postponement. And I would respectfully request 30 days.
Thank you. I see Mr. Sanders has his hand up. Mr. Sanders?
Still trying to maybe find the third way here. What about postponement for 30 days, subject to Mr. Davis's submittal to the board of a stream determination within 25 days or 27 days, so that if he doesn't do that, we can notify Mr. Klein that it's going to be kicked down the road to another month. That way, if he gets it done within the time, then we can come back here and meet and get this over with, or we'll know so Mr. Klein doesn't have to show up to find out there's no determination.
Ms. Rowe, your hand's up.
Yes, first of all, I'd like to make the point that we have a motion on the floor with a proper second that we should go ahead and dispose of. Secondly, I want to make sure that this determination is being made by TDEC. But I call for the question.
Okay, so call the question. If it's seconded, it is not debatable. But before we do that, I would say that there is a motion on the floor. There can be a substitute motion made that would take precedent over the motion. So it's up to you all. If someone seconds Ms. Rowe's call for the question, we'll have a vote on that, and then vote on the.
I'd also point out to the group that we'll have to do a roll call vote, and then on the calling the question, then a roll call vote on the actual question itself. So
did I misunderstand? I thought Mr. Mr. Corcoran made the motion and Mr. Anderson seconded it?
Correct.
Someone,
That's
okay.
correct.
Okay,
And then
thank
we
you.
were, and then we were discussing the motion.
We do have, that's the main motion. We have a main motion on the floor. It's subject to a substitute motions can be made. Ms. Rowe has moved to call the question. If that motion is seconded, we'll have a vote on that motion.
Can the
Otherwise,
substitute- I'm sorry, can the substitute motion be made prior to voting on the first motion or calling the question?
well, the floor is open to second Ms. Rowe's motion at this point.
Hey, Daniel, this is Coach. Can we interject something here?
If we could at least figure out if someone's seconding the calling the question, please. Do I hear anything from anyone on the board? Okay. It does not appear that the question's been called has been seconded. So I think we're still doing further discussion or could potentially have a substitute motion, but Knox County Codes, was it something quick that you wanted to chime in on?
Yeah, we don't think as our engineering department that we can require TDEC to do that determination. Their policy is that third party can do those and submit and they approve.
Yeah, they used to do all the stream determinations. About 5 years ago, they stopped doing them. They have a course that you could become certified to do them. So someone else would have to do it, but it would have to be submitted to TDEC and approved by TDEC, but they don't actually do the stream determination.
We're not 100% sure we can put that requirement on the developer to have TDEC do that determination.
Okay. Thank you. Mr. Thompson, I saw your hand up.
Yes, I will make a substitute motion, which is to uphold the appeal, or I guess in Mr. Sanders' words, to overturn the determination by the Planning Commission. And my basis for that is, just as I expressed earlier, that regardless of how the stream determination turns out, the approval process of the Planning Commission was premature and was flawed and did not allow for proper review.
Is there a second for that substitute motion?
Hold on. For a point of order, Mr. Sanders, that's not what's being appealed. And so you cannot vote on something that is not part of the appeal process. Go ahead, I'm sorry.
If you will, I would caution the board to make a decision on this, or caution the board not to make a decision on this application and this development plan approval based on misgivings about what happened at the Metropolitan Planning Commission. This is a de novo hearing. You all are here to make a decision, a new decision, and it is, you're not entitled to give any weight to what happened at the Metropolitan Planning Commission. If you have misgivings about the procedures followed by MPC with the development plan approval, your decision is new. It's a new hearing, the new procedures here. I'm very concerned about the idea that because something has happened at MPC, we are limited in our ability to correct it here. So this is a de novo hearing, and that means that your all's decision is a new hearing. Mr. Klein gets to present evidence, and Mr. Davis gets to present evidence. And what the MPC did, you can look to that and you can ask MPC for pertinent information, but you're not limited by the procedures that were followed at MPC.
Okay, we have a substitute motion made by Mr. Thompson. Do we have a second? Okay, I believe that motion fails for lack of a second. And I believe we still have the original motion, which was mine, for 60 days. Are there any substitute motions?
I'd like to make a substitute motion.
That I would recognize her.
Ms. Longmire, if you would like to speak first.
If you were going to do the 27-day,
Yes.
that's what I was going to do. You go ahead and make the motion. I'll second it.
Okay, if I can remember what Mr. Sanders said, I'd like to make a motion to extend this for 30 days with Mr. Davis presenting the information in reference to the Blue Line stream in 27 days. Is that all I needed? I think that's what you said, Mr.
Would that be presented to us and perhaps Mr. Klein?
Pardon me?
Would that be, who is it being presented to?
Everybody.
Okay.
Presented for us to vote on. It's a motion.
Do we have a second?
I second that motion.
Okay. We have a substitute motion properly seconded. Do we have any further discussion?
Just one clarification. Sometimes the calendar doesn't work exactly. So, and if Mrs. Kerr would consider possibly the verbiage being to your all's next meeting. I don't know if that next meeting's in 29 days or 31 days, but postponing until the next meeting, not 30 days. And we'd have to have that back within, I can say within, we would be required to have that determination back to you all at least 3 days at a minimum prior to your next meeting.
It's our next meeting on the calendar for the 21st or the 28th. We're on the 28th.
23rd.
23rd. Oh, I'm sorry. I'm looking. Okay, 23rd. So all right, that's about 30 days. So may I revise my substitute motion?
Why are we having it on Friday?
No.
Friday's the 23rd of October.
It's on the 28th.
No, Daniel, I'm sorry, it got moved due to early voting. We had to, we
Oh, okay.
we had to move it up a week because of early voting.
Okay.
So we're having it on Friday, the 23rd.
Friday, the 23rd.
And
So-
this is a question for Daniel. This calendar was set when we were doing in-person meetings and we couldn't get any rooms due to early voting. If we're going to do Zoom, we could go back to the original 28. But that'd be a question for Daniel. Can we do that now that we put out public notice of the meetings?
You'll still be able to do next month. Nothing's ever easy, is it, folks?
And sorry to confuse, make it more confusing, but
We got these from PBA, so I don't know.
we had to do the calendar based on room availability through PBA and early voting. We either had to go like 2 extra weeks, it would have been up into November, or we had to do a week early.
Well, let me take a moment to sort of take control back over the meeting. I don't think we have any motions on the floor currently to change the date of the next meeting. So Ms. Kerr, were you going to make an amendment to your motion?
Yes, I'm going to make an amendment to my motion to extend to our next meeting, October the 23rd, with Mr. Davis providing us information regarding the Blue Line stream by the 21st.
Is that acceptable to the second, Ms. Longmire?
It is acceptable, yes.
Okay.
I'm confused, but it's acceptable.
Okay. So we have a motion to continue this matter to the 23rd of October at a regularly scheduled meeting, and this matter will be heard provided that Mr. Davis provides to this board and provides to this board on the 21st the Blue Line stream analysis, for lack of a better word. Does anyone wish to be heard in discussion on that motion? I see a couple hands up, but I think some of them have been up for a bit.
It was before we, it's my understanding that clarify the motion that if the stream determination is not submitted by the date, then it will be continued to the
Correct.
November meeting.
That's correct. I apologize. Caveat to that,
And I agree.
information is not provided by the 21st and cannot be that the meeting will be extended to the November meeting.
Okay. Does anyone else wish to be heard on that motion?
Could you repeat the entire motion? I'm not sure. It kind of went in and out. I did not hear it all. I apologize.
Kim, did you write that down?
Okay, I have that this is extended or deferred to the next meeting, which will be October 23rd. The Blue Line stream information is to be submitted by the 21st. And if it is not submitted by the 21st, then the item will be deferred to the November meeting. Is that
Thank you.
correct?
I could have probably said it a little more eloquently, but yes, that's the gist.
Okay. Does everyone know what we're voting on? An affirmative vote, I believe, would be to continue the matter as stated. Seeing no further discussion, Madam Clerk, if we could do a roll call vote.
We're voting on the one I just made, right? Not
Yes.
the
Substitute?
substitute motion. Okay.
Ms. Rowe?
Yes.
Ms. Rowe votes aye. Mr. Corcoran?
Aye.
Mr. Corcoran votes aye. Mr. Williams?
Aye.
Mr. Williams votes aye. Mr. Anderson?
Uh,
Mr. Anderson votes aye. Ms. Kerr?
Aye.
Ms. Kerr votes aye. Mr. Harden?
Aye.
Mr. Harden votes aye. Ms. Longmire?
Aye.
Ms. Longmire votes aye. Mr. Thompson?
No.
Mr. Thompson votes no. 7 aye votes, 1 no vote.
All right. With that, I believe the motion carries and the matter is continued as stated. Do we have any other business before the board today?
I don't think so.
Do we have a motion? Ms.
Me?
Longmire?
No, I want to have a question.
Okay.
All right, looking at the November calendar, our meeting on Wednesday, the 25th is the day before Thanksgiving. Does that meeting need to be moved also?
We will send out a new calendar, but the meeting date for November is November the 18th.
Week before.
Okay, thank you.
Yeah, you cut out there, but
I've got
did you say
turkey.
the 18th?
November the 18th, yes.
That's what I had as well. Okay. Does anyone have any other business? Do we have or do we have a motion to adjourn?
Motion to adjourn.
Second.
Any opposition? Hearing none and seeing no business, I believe we are adjourned.
Thank you.